calling the matters of the people versus Timothy Talley Williams. Appearances for the record, starting with Mr. Williams, who's representing himself. It's okay, Attorney Vinek. He's representing himself.
Thank you.
You're welcome. All right, Mr. Williams, can you state your name for the record, please?
Timothy for the record, here by special visitation.
All right, and this is the date and time set for a final pretrial in this matter. We are scheduled for a jury trial on Monday. Attorney Mason has tendered to the court a witness list in this matter, as well as a special jury instruction served for you to be able to see in this particular matter. And let me ask again for the record, you have the right to have an attorney. Would you like to have an attorney for you in these matters, sir?
Well, for the record, I'm here to serve a default judgment. I serve you, Andy Mason, the affidavit. Back.
You did, and I'm in receipt. Oh, go ahead. I didn't mean to cut you off. Keep going.
Yes, on the first, and I gave you 15 days. It was 23 days I gave you, and I haven't received a rebuttal. So I served you guys with a default.
I don't know what a default is. So there's no default judgments in criminal matters. These are criminal matters.
No, Your Honor. The bigger picture is slipping past the courtroom right now. In his mind, he isn't challenging this court at all. He believes he's operating inside a made-up system of authority, a fictional government that exists only in his own imagination and is recognized by no one but himself and a few invisible officials he's assigned roles to. Because you didn't acknowledge his invented filings or respond to his imaginary legal notices, he's convinced he's gained the upper hand. He truly thinks he's arrived today to deliver some kind of automatic ruling against you, as if real courts are bound by rules he just made up. Sadly, this pattern is all too familiar. After watching countless cases like this unravel, it's clear what's happening here. This isn't a legal strategy or misunderstanding of procedure. It's a complete detachment from how law and reality actually work.
So the only default that we have is if you don't appear to answer for a ticket, then the default that goes into place is your failure to answer for a ticket. Once it's established and it's here, I don't have to establish why these are tickets on the docket. That's why they have the jury and the bench trial options for you. These have been matters that have been, unless there's been a motion about a formally written motion about illegal stop or some constitutional violation, these tickets are considered to be valid and true.
No, I answered the affidavit of non-corporate existence.
So Mr. Williams, the answer to the question today is whether you're going to trial on Monday or not. That's all I'm here for.
Well, you guys haven't rebutted my affidavit.
Mr. Williams, again, I'm going to say, Mr. Williams, again, the question for today is whether you're going to trial on Monday or not. That's all. I have officers present. I have officers Evans present. I have Officer McCree present. I don't know if Officer Bush is coming as well, but they are here today to know whether or not they're going to be ready for trial on Monday. We set this jury trial out a long time ago for this trial on Monday. So are we going to trial?
What officer?
We have Officer Evans and Officer McCree present today.
And Judge, I have Officer Nunley. He's trying to check in right now. Faison Nunley.
Officer Bush is here also.
Thank you, Officer Bush. I didn't see. Good morning. Oh, it's Evans Williams. Okay, say thank you, Officer Bush.
Okay, we go to trial.
Okay, so Monday we go to trial. Do you have a witness list or no, it's just you, Mr. Williams?
Yes, I have 3 witnesses.
He isn't stepping in to act as your attorney or take control of your case. He's simply trying to stop you from making the situation worse and adding problems you don't need. The goal is damage control, not representation, even if that message clearly isn't getting through. And this is where the familiar pattern shows up, just like it does in case after case involving sovereign citizens. They don't require opposition to fail because they consistently defeat themselves. The moment guidance appears, they reject it outright, convinced it's some kind of trap. That what's remarkable is that the judge, the lawyers, and even the legal system itself can offer clear opportunities to step back and course correct. Yet those chances are brushed aside, all to defend an argument that makes sense only to them. In the end, the real barrier isn't the courtroom or the law. It's an unshakable belief that they are the smartest person in the room, no matter the consequences.
Mr. Williams?
No, that'll be it.
Okay. All right. So you have a drive unregistered, untitled motor vehicle and drove while unlicensed, and a no proof of insurance. That's one officer. The next officers are open alcohol driver, tinted windows, no seat belt, no driver's license, no insurance, untitled motor vehicle. And then the final officer is going to be drive unregistered motor vehicle, no insurance, no license ever acquired, and tinted windows. Okay.
And Your Honor, if I may interject, since he does have an email, I can copy those tickets and email them over to him.
Please.
So that he can have them. I'll come down and
Thanks.
get those. And I will email those tickets over to you, Mr. Williams.
Okay.
So that way
And
you can see what
for
the
the record,
tickets
are we able to argue these matters right now, or are we going to trial? Is
You
it
said
possible
you
we
want to
can-
have a trial. What you want to argue?
Yeah,
You
but
want
I'm
to talk
saying,
to
like,
Attorney
I'm-
Mason?
What was that?
I said you want to talk to Attorney Mason just briefly in a breakout room and see if y'all can resolve any of the tickets.
Well, we was just emailing, and I don't know if it meant anything to her, so that's why I wouldn't just take it to trial.
Well, because you can't say I just want you to dismiss it because I'm not a citizen. That's not gonna work. Or I just want you
Oh
to
no,
dismiss
that's not it. I got laws stating that all this is frivolous, but I'm saying, can we argue this right now, or do we?
A
Can
lot
we
of people
resolve it
will
today?
say the laws are frivolous. Well, yes, if you have some argument that you would like to make, you can make it that way. I can rule, and that way we can go to, if we're gonna move forward to trial, we can go to trial. Yes, Attorney Soroki?
Yeah, if you like, I could speak to Mr. Timothy Williams in a breakout room for a few minutes, explain the legal system to him.
Yes. Can you?
No, sir.
Do you want to make your argument first, Mr. Williams, or do you want Attorney Soroki? He wants to give you a little feedback. That way you'll be prepared for Monday's trial. No? All right. He doesn't want it, Attorney Soroki. Thank you, though.
Would it be possible for you to actually study the relevant laws before returning to this courtroom? At the moment, what you're offering isn't a real legal argument. It's the same small set of references that repeatedly show up in similar cases, regardless of whether they apply to the issue at hand. Those citations don't address the rules surrounding the operation of a motor vehicle at all. Instead, they are being reused out of habit, not relevance. It creates the impression of confidence without substance, where unrelated material is presented as proof of something it was never meant to support. If you truly intend to question how the legal system works, preparation matters. That means understanding the subject you're challenging and presenting information that actually fits the situation. Repeating misapplied case law may feel persuasive to you, but in this setting, it only highlights a lack of understanding rather than strengthening your position.
Back on the record in the matter of the People versus Timothy Williams, can I have appearances? First Attorney Mason, then Mr. Williams.
For the record, Your Honor, Diachiku Mason, City of Detroit, 43471.
All right. Mr. Williams.
Yes, Timothy before the court, here by special appearance.
All
As
right.
a state citizen, not a U.S. citizen.
Okay. Changes every time. All right, you want to make a motion or you want to make an argument as to these tickets? You can go ahead at this time, Mr. Williams.
Okay, for the record, for the record, Shapiro versus Thompson states that all citizens must be free to travel throughout the United States, uninhibited by statutes, rules, or regulations, which unreasonable burden or restrict movement. Did you get that?
I'm listening. I'm just writing down. You see, I got my notepad.
Okay.
I'm writing down notes.
And then Murdoch versus Pennsylvania, the Supreme Court decided that a state cannot arbitrarily or erroneously convert a secure liberty, in this case, the secure right to travel, into a privilege and charge of or issue a hold on. A state can't arbitrarily or erroneously convert a secured liberty into a privilege and issue a license and a fee for it, meaning we don't need license or insurance to travel throughout the land. And Murdoch versus Pennsylvania states no state converts security liberty to a privilege. No, Shuttlesworth versus Pennsylvania. No, Shuttlesworth versus Birmingham, Alabama. You can ignore the license and engage in the right with impunity if you happen to have a license. And back to Murdoch versus Pennsylvania, no state may convert a secure liberty into a privilege. So no state has a right to require you to have a license. Hold on.
It's life, liberty, and the pursuit of happiness. Period. That phrase stands on its own, exactly as it has for generations. You don't get to take one of the most well-known lines in American history and casually add extra words to it as if it were a rough draft that can be edited to fit your argument. What makes this even more telling is the confident way it was presented as constitutional law. Despite all the talk of deep legal knowledge, that quote was attributed to the wrong place entirely. It doesn't come from the Constitution, and it certainly isn't part of the First Amendment. The line appears in the Declaration of Independence, a foundational document with a very different purpose and legal standing. So the issue isn't just a minor wording mistake. The quote was altered, and the source was misidentified at the same time. That doesn't demonstrate mastery of the law. It highlights a basic misunderstanding of the documents being relied upon.
Okay, so that's your argument as far as no state can force you to have a license.
Require.
Because it's a constitutional right to travel.
Which is our First Amendment.
So this right to travel was about a welfare case, Mr. Williams, where she wanted to go to a different state, and they told her that because she didn't have established residency in that she was going to be denied services.
Right, and that violated her.
Right, because it's talking
right
about
travel.
services. She needed to take care of her child. She was 19 and she was pregnant.
But you avoid the facts of the case. Even though that she filed a lawsuit against the state for denying her privileges, but the Supreme Court ruled that the Supreme Court ruled that can't happen because that also be violating her right to travel throughout the states, throughout the land.
To receive the benefits that she needs in order to take care of herself and her child.
Yes, but you're missing the argument that the Supreme Court has stated. That'll be violating her First Amendment right, life, liberty, and pursuit of happiness.
It seems there's a serious misunderstanding about what Shapiro versus Thompson actually addressed. While the case did involve the right to travel, its focus was very specific and far more limited than what's being suggested here. It was not a ruling about driving, licenses, or the constitutionality of motor vehicle regulations. The Supreme Court examined a Connecticut policy that made it harder for people, particularly low-income individuals, to move freely between states. That policy discouraged relocation by delaying access to welfare benefits, and the court ruled this restriction violated Ms. Thompson's fundamental right to travel within the United States. That decision had nothing to do with operating a vehicle, licensing laws, or traffic regulations. It did not eliminate state authority over driver requirements, nor did it create exemptions from those rules. Connecting this case to arguments about driver's licenses goes beyond what the court decided and stretches the ruling far outside its actual legal meaning.
I don't want you to miss that fact. That's what they ruled.
They said the closest the Supreme Court has come to overturning Shapiro Thomas was in 1995 with Anderson versus Green, California Welfare and Interstate Code annotated section, instituted a 1-year residency requirement for welfare aid, violating Shapiro versus Thompson. Both lower courts in California affirmed that violated Shapiro versus Thompson and granted an injunction. I'm sorry. Due to the procedural issue, California's residency requirement never went into effect, creating no justifiable controversy action and no actual issuance for the court to rule on. Whether they receive a waiver from the Secretary of Health or Human Services to set aside Shapiro versus Thompson, making the residency requirement pseudo-legal, the waiver was challenged again, and it's holding that the state court and the Secretary of HHS had not adequately considered public comment on the issues. So this just talks solely about, even talks about the social impact. The social impact and the legal impact is that you can go different places, and we as the governments of each state still have a requirement to take care of those citizens within our state. This is about welfare. Yeah, this is about the welfare system and the ability for people. You cannot stop people from traveling. I don't see anything in here about a driver's license.
Look, the decision of the court.
Right, she has the right to go places.
Look, the court reaffirmed the right to travel under the 14th Amendment Privilege and Immunities Clause in Suez versus Roe. So they conferred it to another case. But the conclusion of the case like that would be violating her right to travel. It can have something to do with the welfare, but it's violating her right to travel.
And just like Shapiro versus Thompson, Murdoch versus Pennsylvania has no connection whatsoever to driving without a license. It isn't even about the right to travel. The case sits firmly in an entirely different area of law and deals with a completely separate constitutional issue. Murdoch was a First Amendment case centered on religious freedom. The dispute involved a local tax imposed on people who were going door-to-door distributing religious pamphlets. The Supreme Court ruled against the tax because it placed an unfair burden on religious expression, not because it touched on transportation or vehicle use in any way. There was no discussion of cars, roads, licensing requirements, or state authority over drivers. The ruling focused solely on protecting religious activity from improper government interference. Trying to reshape the decision into an argument against driver's licenses ignores both the facts of the case and the court's reasoning. Saying Murdoch to challenge licensing laws doesn't strengthen an argument. It reveals a misunderstanding of what the case actually decided. When legal precedents are pulled out of context like this, they don't support the claim being made. They only highlight how far removed the argument is from established law.
Because the reason why we can't prohibit her from being able to travel or to go to another state is because then they're saying once she gets to that state, she has to establish some type of residency. And what they're saying is that if she doesn't have that residency, she wouldn't get the services needed. And so they're saying you can't say, oh, you can't go to this state and not get the stuff that you need to take care of yourself and your family just because you're not. I can't stop her. I can't say you can't move to this state and then we're going to block everything. I can't do that. Right. This is not about a license.
Which will violate the right to travel.
No.
That was the decision of the court. I'm not making that up.
You aren't, but you're not understanding what their decision was based on. Yes, you have the right to travel, but this is concerning services.
So if I chose to carry a weapon, I will be bearing arms.
If you chose to carry a weapon in the state of in Illinois, that's an automatic. You're not allowed to carry weapons at all in the state of Illinois unless you're a law enforcement officer. So if you traveled over the state lines and you went to Illinois and you tried to carry a gun, they would tell you no.
But that's irrelevant, Your Honor. We're talking about the state of Michigan. I have a right to bear arms, but you will call it receiving.
Exactly.
But the Constitution of Michigan states that I can bear arms, but
because once again, and we had this conversation already, the states can make stuff more, the localities can make stuff, they can, and it's a state law anyways, but they can be harsher than the U.S. Constitution, but they can do something that would take away from the U.S. Constitution. So they're not taking away your right to bear arms, they're just putting parameters around that right. And recently it was challenged at the Court of Appeals when someone tried to say that the people have the right to bear arms, and that seeing a bulge or doing stuff like that didn't equate to it. And the Court of Appeals has said and ruled that that does give probable cause for an officer to ask about whether or not they have the licensing, because the state has determined that they need to have the licensing. So if the state determines that there needs to be a certain licensing in place and that rule or that is violated, then that has to go forward.
But that's kind of irrelevant.
Okay.
And like Murdoch versus Pennsylvania say no state can convert a secure liberty into a privilege.
The speaker begins by confidently invoking secure liberty, blending phrases together as if they all come from the same legal source. He claims the First Amendment guarantees life, liberty, and the pursuit of happiness, then immediately ties that idea to an unrestricted right to move freely across the country. According to him, simply traveling from one place to another, without causing harm, places him beyond regulation, and the court's role, in his view, is to protect that belief rather than question it. He insists he is relying on constitutional principles, not acting recklessly or without direction. To support his position, he mentions federal cases by name, suggesting that his argument is grounded in law. But when pressed, it becomes clear he is selecting only the parts of those cases that seem useful to him, while ignoring the rest. That selective approach is exactly where the problem begins. The judge steps in to clarify the issue. The law, the judge explains, cannot work if people choose only the rules they like and discard the rest. That kind of pick-and-choose approach doesn't lead to freedom. It leads to disorder. The judge offers a simple comparison. Claiming legal authority without following the required process is like announcing you're a judge without ever meeting the qualifications. The system doesn't operate that way. The defendant pushes back, saying he understands the court's point but disagrees with the conclusion. He brings up another federal statute, believing it strengthens his position. At that moment, the judge redirects the conversation to something practical, the upcoming trial. A clear choice is presented: move forward properly, or risk undermining his own case. The judge explains the boundaries clearly. At trial, arguments must focus on facts, evidence, and procedure, not broad theories about constitutional law. The jury will not be there to hear debates about misunderstood statutes or misapplied cases. If those arguments are raised, objections will follow, and they will be sustained. The discussion must stay centered on what actually happened during the traffic stops and what the officers are there to testify about. When the defendant claims the stops themselves were unlawful, the judge reminds him that he was given ample time to file motions raising those issues. He chose not to. Now, the court is dealing with the citations as they were written, based on a ruling already made that the officers had the authority to stop him. Still, the defendant returns to familiar talking points. He argues that he is not a person under the law, but a human being. He says he has no contract with the state, that he was not driving for profit, and that moving from point A to point B should not require compliance with licensing laws. He repeatedly frames these claims as the exercise of constitutional rights. This is where the pattern becomes unmistakable. The confidence is absolute, but the understanding is shallow. Laws are quoted without context, cases are referenced without comprehension, and complex legal systems are reduced to slogans. It's a reminder that certainty alone doesn't equal correctness. In court, knowledge matters, preparation matters, and confidence without understanding rarely leads to the outcome people expect.
Our secure liberty, First Amendment, is the right to life, liberty, and pursuit of happiness.
Mm-hmm.
Right to travel throughout the United States of America.
Right.
Freely and unencumbered. We're not causing harm to anybody. We just obeying the constitutional rights. Exercising our constitutional rights, which is the court is here to help protect them. I'm relying on the constitutional rights. I'm not just out here willfully nilly, like United States versus Bishop.
But you are, because you're only taking the part that you want to be applied to you. So you are out here willy-nilly. Because if you were following, if you were following everything, you would want to follow everything and all the rules that were put into place. So all that
I'm following laws,
not following what you want to follow. And that's no. We talked about how that leads to anarchy. People can't do whatever they want to do. They say that I can follow only this. That's no. That's like me coming one day and saying I want to practice law and I want to be a judge, and I haven't gone through any of the things to become a judge. That's not how it works.
I see how you
I
put
can't
it,
sit
but
up
that's
there with
not.
a fake P number. They wouldn't let me do that.
I see how you put it, but that's not true. What about Title 18 USC Section 241?
So Williams, do you want a trial on Monday or not? You can't argue this stuff to the jury.
Yeah, I want to go to trial, but I can't.
Okay. You can't argue this stuff to the jury. You can argue that maybe something, making sure that they didn't check the things. Like, you have to follow the law. I have to treat you as an attorney in that place on Monday. So I have to treat that you know how to practice and go about the way of law. And these different things, like, you can't just give the jury cases and stuff like that. That's not what it's going to be about. And you'll most likely end up with objections that I'll have to sustain, because it's going to be talking about the facts of these particular cases where the officers came today to show up. So it has to stick to those things about what the officers came to argue about, or what Attorney Mason will make the argument for, and the officers came to testify about.
What are they testifying about?
About these different stops.
Which is unlawful.
Different tickets. Okay. Well, I gave you plenty of time to write a motion about unlawful, and you did not want to. So
that's
now we're here.
Permission. I gave you affidavits stating the facts, what you needed, and
exactly. And the facts are to be argued before a jury. If they differ from these facts that on the tickets, we're here to talk about these tickets. I've already made my ruling long ago that they had the right to stop, and that these tickets are the tickets for which they wrote them for.
Yes, they have a right to stop persons, but I'm not a person. I'm a human being. I have no contract with the Secretary of State. I'm traveling. I'm not driving. I'm not driving for gain or profit. I'm going to point A to point B, not violating nobody's rights. I'm just traveling freely, like I exercise my constitutional rights. Like Title 18 USC.
And yes, rules and regulations are, in fact, laws. This really isn't complicated. One of the simplest ways to understand it is by looking at everyday examples, like speed limits in Texas. When a sign lists a maximum speed and a driver goes beyond it, that action isn't just discouraged, it's a legal violation. The authority for that rule doesn't come out of thin air. It's written directly into state law, specifically the Texas Transportation Code, Section 545.352. That statute clearly explains how speed limits work and when they apply. This is the normal structure of the legal system. Laws are written into statutes, and those statutes tell people what is required and what is prohibited. That there's no special category where certain rules somehow don't count as real law. Statutes are laws, and laws are enforced through courts every day. They aren't symbolic, optional, or imaginary, and they don't depend on personal agreement to be valid. Whether someone chooses to acknowledge them or not doesn't change their effect. These laws are debated, passed, recorded, and enforced through established legal processes. Ignoring that reality may feel empowering, but it doesn't alter how the legal system actually operates. I let you have a whole hour of time to discuss all of these previously, Mr. Williams. We talked about all of these, and at the end I made the ruling that the court did have jurisdiction and that the officers could write tickets.
You haven't explained jurisdiction.
I don't have to explain anything. It's not my job to explain it.
But you said you did explain, but you didn't. But
I said I allowed you to explain it. Do you need to put it up on YouTube?
But the burden is on the prosecutor.
Right, not on me. I'm the court. I just call balls and strikes.
And the prosecutor cannot state how she has jurisdiction.
Okay, Attorney Mason, do you want to state how you have jurisdiction over these matters?
Statute provides us with the jurisdiction over this matter. The statutes and the laws of the court provide the jurisdiction over these matters.
That's subject.
I am empowered by the state. I am empowered by my bar card, which has been submitted to the state of Michigan. I'm empowered by the city of Detroit.
Does she I gotta object
And
to
the
that
what?
because she's not stating how she has jurisdiction over
She's telling you it's by the statutes. The statutes that were given.
statutes is not law.
Okay.
I'm obeying by the law.
So you want us to call them laws? Laws are statutes. They're the same thing. It's just a fancy way of saying laws. Statutes are just a fancy way of saying
statutes
laws.
are persuasive. Laws
Okay.
are mandatory.
These are laws. Okay, statutes are laws. It's just a fancy way of saying laws.
Yeah, they derive.
If people who reject basic law were left entirely to run things on their own, order would disappear almost overnight. Systems only function when everyone agrees to follow shared rules, even when they don't personally like them. That's why courts, procedures, and accountability exist in the first place. That brings us to the close of today's report. The individual involved had an in-person jury trial scheduled for Monday. I waited to see whether the court would upload footage or records from that hearing, but so far, nothing new has appeared online. I did review the official case file, and at this point, the outcome is still listed as unresolved. There are a couple of possibilities. The court may simply be delayed in updating records, which happens more often than people realize. The other possibility is that the defendant failed to appear, something that has occurred in similar cases before. Until the court updates the docket, we won't know for sure that if you found this breakdown helpful or informative, consider showing your support. And if you have thoughts on the case, feel free to share them. At
this point, Your Honor, I'm going to
rules and regulations.
I'm going to just make a motion that these matters have already been resolved. That the court has previously stated that the trial was set forth regarding the facts of the incidents that have arisen, and that the witnesses will testify only to the facts regarding the tickets.
What are the facts?
The facts are the things on the ticket. So you have to research the law and find out exactly what each one is to show.
According to Michigan Vehicle Code 257-744A, police officers knowingly make a false statement on the citation is unlawful.
Okay.
I travel with a passport. My ID been canceled since 2018, so none of that is true.
Just because you cancel your ID, and this is the last argument for today, and then we're just gonna have trial on Monday. Just because you cancel your ID doesn't mean now you have the right to drive in the state of Michigan. That's not the law of this state. When you avail yourselves of the roads, the lights, the streets, the anything. Once you avail, once you take part on those items, then you automatically allow yourself to avail yourself to any laws that are being taken place, any statutes that are being taken place, any codes that are taking place. All of those now become active, whether you want them to or not. There's no, I don't want them to.
They become active when you agree to the stipulations.
You don't have to agree. It does not say that. We have stuff called strict liability crimes. And those are crimes that automatically kick into place whether you agree for them or not. And that's what these are. Whether you agree or not, they are things that must happen. So
I agree that certain people, I agree.
9:30. I'll see everybody at 9:30. Listen, either you're gonna take care of these things.
Certain persons need to be governed, but everybody is not to be governed. Certain people know how to govern ourselves.